it's fine. The court's open. The court's open. We can't take anybody out. Okay, it's gonna take 15 seconds before the breakout room closes. Oh, a second. Okay, I don't know that he's still there. Mr. Schenkel? Okay, it's likely that the jail has removed him.
I believe we can still move forward, Your Honor.
On the record in the matter of the people of the state of Michigan versus Sidney Harlan Schenkel, file numbers 21-01593, 21-01564, 21-01130. FY, council appearances, please.
Thank you, Your Honor. Erin Hoskell on behalf of the people.
May it please the court, Brian Laxton here on behalf of Mr. Schenkel.
Thank you. Today's the date that was set for competency review or competency hearing for Mr. Schenkel. We had previously ordered him to undergo evaluation as to competency and criminal responsibility. I do have a report, or multiple reports. I think one report actually was sent to Judge Aquilina on one file. The other one is addressed to me, but did both parties get a copy of the report from the Department of Health and Human Services?
Yes, Your Honor. Thank you. The people have a copy of a report from Dr. Deanne Yunt dated November 9th, 2021.
Your Honor, we also have both reports. I believe they are similar, if not identical in nature. We do have copies and supplements to those reports dated November 17, 2021, which is also from Deanne Yount.
Yes, I believe that they are identical reports. Nonetheless, the body of the report concludes that the Forensic Center has determined that Mr. Schenkel is not competent at this time to stand trial, but they are of the opinion that there's a possibility that he could be restored to competency within the statutory time limits. Is there any objection to the body of the report or the conclusion?
No objection to the conclusion, Your Honor. Thank you.
No objection, Your Honor.
Okay, and Mr. Schenkel was before the court on Monday when we attempted to address this. His behavior was erratic at that time, and then my understanding from your interactions with him today is that you were not able to even have a private consultation with him due to his mental state. Is that correct?
That is correct, Your Honor. I had attempted to discuss just even the procedure or even what is going on, what would be going on today. And Mr. Schenkel's mental state was such that it is very apparent that in my mind, that the conclusions in the report are valid. He was combative, he was aggressive, delusional. I would also note for the record that I had extensive discussion with Mr. Schenkel's mother to get a little bit better background so I could understand Mr. Schenkel's situation and give a better recommendation for Mr. Schenkel. And it is her recommendation that Mr. Schenkel be sent back to the forensic center. Evidently, he was there at one point, and they were able to help him at least temporarily. So she is of the mindset that a remand to the forensic center to such time that he is deemed competent would be very reasonable and well within the parameters of what's appropriate for Mr. Schenkel. And I would concur with that.
Thank you. Ms. House, did you want to make a statement?
Yes, Your Honor, thank you. The people would also agree and ask that the court order the continued treatment through the Center for Forensic Psychiatry due to their recommendation, the Dr. Yunt's recommendation that she believes that he may be able to regain competency within the statutory timeline.
Defendant will be remanded to the custody of the forensic center. The court will adopt the report. It will become a part of the court record. And he will be ordered to undergo treatment or a course of treatment to see if he can be restored to competency within the statutory time period. And so we'll set this matter out for a review date so that we can get a status a little later along the lines. As it relates to criminal responsibility, the Center of Forensic did submit an order or a report to the court indicating that they were not able to complete the evaluation. And so if he is able to be restored to competency, that is still a request or concern, he would then need to be reordered to have an evaluation as to criminal competency. But at this time, they were not able to complete that. So we won't address that until he is back from the forensic center.
We concur with that, Your Honor.
Thank you, Your Honor.
Thank you. Are there any additional matters for the record?
Nothing for the people, thank you.
Nothing from us. Happy holidays to all.
Thank you. Same to you.
Thank you.
All right, I know that's after I do that. Mr. Keithley, did you have a plea or someone had a plea?
Yes, Your Honor.
Okay. Sir, what's your name?
Kyle Lauer.
Ms. Dolly, did you need to speak to him?
Yes, Your Honor, I will.
Okay, let me reset these breakout rooms because they're just 60 seconds. Okay. On the record in the matter, the people of the state of Michigan versus Taylor Rose Jungle. File number is 21-02608. Counsel appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Taylor Jungle, who's present via Zoom.
Okay, good. Today's the date and time that was set for a preliminary examination. How do we want to proceed on this?
Thank you, Your Honor. It's my understanding that the defendant will be entering a plea this morning.
I'm on the record.
Thank you, Your Honor. The defendant is going to plead guilty to an added count 4 of attempt R&O pursuant to 750.8 1D1 bracket A. The maximum penalties on that, Your Honor, are 1 year and or $1,000. She's also going to plead as charged to count 3, the assault and battery, pursuant to 750.81. The maximum penalty on that, Your Honor, is 93 days and or $500. There's a Killebrew agreement, Your Honor, that she be sentenced under the Holmes Youthful Trainee Act. In consideration for that plea, Your Honor, the people would move to dismiss counts 1 and 2.
Okay, Mr. Keithley?
That is a complete and accurate statement, Your Honor.
Okay, Ms. Jungle, how are you?
I'm good. How are you?
I'm doing very well, thank you. So today was the date that was set for your preliminary examination. My understanding is that you would like to accept the offer extended by the people, which is for you to plead guilty to an add count 4 of an attempted R&O, and then which is resisting and obstructing an officer, and also you would be pleading guilty to the count 3, which was an assault or assault and battery. Is that what you understand your plea agreement to be, ma'am?
Yes, Your Honor.
And there's a Killebrew agreement for you to be sentenced under HIDA, which is the Holmes Youthful Trainee Act. And that Killebrew is an agreement between you and the prosecutor. The court's not a party to that. Do you understand that?
Yes, Your Honor.
So that means that at the time of your sentencing, if I'm not going to follow that agreement, I would then give you an opportunity to withdraw your plea. Do you understand that?
Yes, Your Honor.
Okay. Can I have you raise your right hand, please? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Ms. Jungle, you have the right to proceed to a trial in this matter. You have the right to have a jury trial. At the time of your trial, you have the right to have the prosecutor bring sufficient evidence to prove each element of the charges that are being brought against you. They have to prove each element beyond a reasonable doubt. If you want to plead guilty today and accept this offer, you'd have to give up your right to have a trial of any kind. Is that what you want to do, ma'am?
Yes, Your Honor. I understand.
Okay, so that means you will not have an opportunity to cross-examine any other witnesses that they intended to call. You would never have an opportunity to call your own witnesses or present evidence to further any defense you believe you may have. You also waive your right to remain silent at trial and not have silence be used against you. Is that what you want to do today?
Yes, please, Your Honor.
Okay, has anybody made any promises to you to get you to waive your rights?
No.
Are you being threatened by anybody to get you to waive your rights?
No, ma'am.
Are you pleading guilty because you believe you are guilty?
Yes, ma'am.
Are you currently on probation or parole?
I am not.
Okay. As to the added count 4 of attempted resisting and obstructing an officer, how do you plead?
Guilty, Your Honor.
And as to count 3 of assault or assault and battery, how do you plead?
Guilty, Your Honor.
Mr. Keithley, can I have a factual basis?
Thank you, Your Honor. Ms. Jungle, on or about August 4th of 2021, were you in the area of 414 East Michigan Avenue in the city of Lansing, Ingham County, state of Michigan?
Yes, sir.
And at that time, did you have interactions with some police officers?
Yes, sir.
And did you have reason to know that they were police officers?
Yes, sir.
And that was because they were wearing their full police officer uniforms, right?
Yes, sir.
All right. Now, at some point, one of those officers ended up putting you under arrest, right?
Correct.
And he transported you over to, I guess, another officer's squad car, right?
Correct.
And when you arrived at that squad car, he tried to put you in the squad car, right?
Correct. Yes.
And you actively resisted being put in the squad car, right?
Yes, sir.
And you did that by actually putting your feet up and pushing on I believe the door frame, right? So that he wouldn't be able to put you in?
Yes.
Okay. Now, eventually you did get loaded into the car, right?
Yep.
And at some point in the evening, officers ended up taking you over to McLaren Hospital in Lansing, right?
Correct.
And you ended up having interactions with a nurse at that time, right?
Yes.
And the nurse tried to put an IV into your arm, right?
Yes.
And while she was doing so, you grabbed onto her arm, right?
Yes.
And she didn't give you permission to grab her, right?
No, sir.
And while you grabbed onto her, you actually, your nails actually cut into her arm, right?
Yes, sir.
And caused some scratches, right?
Correct.
All right. I have no further questions, Your Honor.
That sounds good.
Your Honor, thank you. I would just ask that the record reflect that the nurse that she's made the admissions regarding is named Amanda Thiessen for purposes of the complaint. Thank you.
No objection, Your Honor.
Thank you. The record will reflect such. The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing on January 20th, 2022 at 8:30 in the morning. That can be via Zoom if all parties consent.
The people would consent, Your Honor. Thank you.
We have no objection to that, Your Honor.
Prior to sentencing, Ms. Jungle, you're going to need to meet with probation. They're going to provide the court with a pre-sentence report and recommendation. You need to report to them within the next 2 business days, okay? So by
Okay.
Tuesday, okay? Okay.
Yes, ma'am.
Do you have any questions today, ma'am?
No, I do not, Your Honor.
Any additional matters for the record, counsel?
Nothing for the people. Thank you.
Your Honor, as the court's aware, we are going to be seeking HIDA status in this matter. Would the court like me to file a petition for that, or is the agreement sufficient for the court?
The agreement is sufficient.
Thank you, Your Honor.
Thank you. You're all set. Thank you, Ms. Jungle.
Thank you very much, Your Honor.
Okay, Mr. Palmer is representing Mr. Clay.
Your Honor, I'm
Yes.
filling in for Mr. Palmer regarding both Mr. Clay and I believe Ms. Hodge. That's the one we talked about yesterday, right, Aaron?
That's correct. Your Honor, may we do Ms. Hodge first?
Okay, no problem. We're on the record in the matter of the people of the state of Michigan versus Jamie Lynn Hodge, file number 21-02141 FY. Counsel appearance, please.
Thank you, Your Honor. Aaron Hospital on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Ms. Hodge.
Thank you. Today's the date that was set for a probable cause conference. How are we proceeding on this?
Thank you, Your Honor. I have signed and provided to the court this morning a nollie for dismissal without prejudice in the interest of justice for Ms. Hodge's case.
The court is in possession of section. I've signed it. This case will be dismissed without prejudice. Any additional matters for the record?
Nothing for the people. Thank you.
No, Your Honor. Thank you.
Thank you. You're all set, Ms. Hodge.
Thank you.
You're welcome. Okay, did you need to speak with Mr. Clay at all?
No, Your Honor, I'm all set.
We're on the record in the matter of the people of the state of Michigan versus Comanche Blake Clay, file number 21-03130. Counsel appearance, please.
Thank you, Your Honor. Aaron Hospital on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender. I'm filling in for Assistant Public Defender Robert Palmer, appearing on behalf of Comanche Clay, who is present.
Thank you. Comanche Clay, is that you, sir?
Yes, ma'am.
Okay, thank you. Today's the date that was set for probable cause conference. Mr. Keithley, how are we proceeding on this?
Thank you, Your Honor. No offer has been extended in this matter, and we would normally be requesting to just leave it on for exam. Unfortunately, at this point, my office has yet to receive any discovery relating to this matter. So my intention was request that next week's hearing be converted over into a probable cause conference such that we have an opportunity to review the discovery prior to making any decisions about the exam. And of course, Mr. Clay would be able to elect to either waive the exam or perhaps have the exam adjourned out at that time.
Okay, No problem, we can do that. Is there any reason why discovery was not sent?
Excuse me, Your Honor.
Yes, Mr. Clay, do you have a question?
Yes, ma'am. Now, as far as the discovery goes, is there any possible way I could just like waive the prelim now and just plead guilty to the charges? Because I mean,
Your attorney, I'm gonna stop you now, sir. Your attorney hasn't even reviewed the discovery. So it's not even in your best interest to do that, sir. Let them review this discovery and advise you as to what your best decision is at that time, okay? They could, but you don't know what's on the discovery. They can review the discovery and believe that, your rights were violated and want to file a motion for all you know. And you're trying to waive it before they get. So with that being said, we'll treat next week as your probable cause conference. Mrs. Housefeld is looking into what happened, why the discovery wasn't received, if she knows.
I don't, Your Honor. I do see that the people have an appearance from Mr. Palmer dated the 19th of November. I don't know why that was not processed. I don't know what date we received it. I simply show that we do have one in the file and it is signed for the 19th. My apologies to the court and the PD's office. I don't know the answer.
Okay, sounds good. So hopefully the discovery will be exchanged and reviewed by next week. And you will have had conversation with Mr. Palmer, Mr. Clay, by then so that you can discuss what your best course of action is from that point is, okay?
Yes, ma'am.
Is that a yes?
Yes, ma'am.
Okay. So any additional matters for the record, we'll just treat next week as a PCC.
All right.
Nothing for the people. Thank you.
No, Your Honor, thank you.
Thank you. You're all set, Mr. Clay. Ms. Hodge, you were free to go. Unless you had a question. Okay, are we ready with Mr. Lauer?
Yes, Your Honor.
People are.
Thank you. On the record in the matter of the people of the state of Michigan versus Kyle Evan Lauer, file number 21-02279. Can I have your appearances, please?
Thank you, Your Honor. Aaron Housel on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Kyle Lauer, who is appearing separately by Zoom from Ingham County Jail.
Today's the date scheduled for a probable cause conference. How do we want to proceed on this?
Your Honor, I'm in a similar situation, Mr. Keithley. Mr. Lauer, we're favoring waiving our preliminary exam rights, but I don't have discovery yet. So we've discussed about what we wanted to adjourn, but I think if at all possible, have this treated like a PCC next week with the preliminary exam, possibly after that. But once I review discovery with him.
Very good. We will treat next week as a PCC. And hopefully discovery will be received by then. Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
No, Your Honor. Thank you.
Thank you. You're all set for today, Mr. Lauer.
Thank you.
Thank you. Who do you have there? Mr. Mills.
Your Honor,
How are you?
I'm delightful. How are you doing?
I'm pretty good.
That's good.
Alicia Bernard.
Yes, I represent her. And she is she's on her way. She's on her way still. I'm gonna go check the hallway one more time, Your Honor. She's driving from Detroit or whatever. Yes, Your Honor. I would like to go check the hallway if that's okay.
Please do. Please. Mr. Abbott, what do you have with you?
Morning, Your Honor. Corey Lewis is here for a PCC.
Are we continuing to exam or did you not do discovery?
Oh, I've got discovery, Your Honor. We decided we'd like to hold an exam.
Or Corey, what's his last name?
Lewis.
Lewis. Corey Lewis. Okay, very good. On the record in the matter of the people of the state of Michigan versus Tory Deshaun Lewis, file number is 21-03108. Council appearance.
Thank you, Your Honor. Aaron Housel on behalf of the people.
Good morning, Your Honor. John Abbott from the Public Defender's Office representing Mr. Lewis. He is present and standing to my right.
Today's the date that was set for probable cause conference. How are we proceeding on this?
Your Honor, the defendant would like to hold a preliminary exam, Your Honor.
Okay, your exam scheduled for next week at 8:30 in the morning, okay? Do you have any questions today? Any additional matters for the record?
Nothing for the people, thank you.
Nothing from the defense, Your Honor.
Very well, we'll see you next week at 8:30, okay, sir?
Wow,
Thank you.
thank you.
Okay. I saw an email that the jail will be here by 9:20. That's what this email says.
That means I can get them like 20, 30 minutes after.
Except between receiving and transfer, we should have them to you by 9:20.
That's correct.
Well, that's unfortunate. Let's see here. Is this the phone number you have, the number that ends in 0989?
Yes. I tried it twice and no success.
Okay, well, I'll issue a bench warrant.
And then, Your Honor, should we leave the PE date on and treat it as a PCC in case he appears?
We'll do that.
Call off witnesses? Okay,
Yes,
thank you.
please. You need to speak with Mr. Crabtree when he comes. Is that what's going on? Okay.
Yes.
My understanding is that the jail is gonna be here by now.
Okay.
They, On the record in the matter, the people of the state of Michigan versus Jeremy James Crabtree, file number 21-03072. Council appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Crabtree. He is present and standing to my right.
Thank you. This is the set for preliminary examination. How are we proceeding?
We're going to have an examination.
Are we ready to proceed right now?
Yes.
Yes.
Okay. Any preliminary matters before you call your first witness?
Just for Your Honor's court recorder, I set an exhibit on her keyboard that I would ask to be marked. Other than that, nothing preliminarily for the people, Your Honor.
Nothing for the defense, Your Honor.
Thank you.
Be seated. You can call your first witness.
Thank you, Your Honor. The people would call to the stand Trooper Robert Galapel.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat there, Trooper. Can you please state and spell your first and last name?
First name is Robert, R-O-B-E-R-T. Last name is D as in David, E-L-L-A, P as in Paul, E-L-L-E, Galapel.
Thank you. You can proceed, counsel.
Thank you. Sir, could you please state your occupation?
I'm a state trooper with MSP,
And how long have you been with Michigan State Police?
about 7.5 years.
And were you on duty on November 9th, 2021?
Yes.
What did your duties that day include, sir?
General road patrol and traffic enforcement.
And at or about 1,500 hours on that date, do you recall where you were?
Yes.
And where were you?
In the city of Lansing, I believe on Cedar Street, if I'm not mistaken.
Are you familiar with the Ingham County jurisdiction?
Yes.
And is that location within the county of Ingham, state of Michigan?
Yes.
And were you in a marked patrol car at that time?
Yes.
What were you doing specifically?
I was traveling behind Trooper Mater, who was driving in front of me, who was also in a fully marked patrol car, and he was getting ready to make a traffic stop.
And are your cars equipped with a radio system where the cars may speak to each other?
Yes.
And were you in observation of radio traffic regarding that traffic stop?
Yes.
And what was the purpose of the traffic stop?
To make a traffic stop in the vehicle, because if I recall correctly, the plate returned EIV no, which indicates the vehicle is not insured.
Do you recall the type of vehicle?
The four-door passenger car, I don't recall the make or model.
And was a traffic stop effectuated?
Yes.
What was your involvement in that traffic stop?
I was behind Trooper Mater probably by 4 or 5 car lengths. And before he activated his lights to initiate the traffic stop, the vehicle pulled into a parking lot for a strip mall and then started to drive south in the parking lot. And I pulled off into the first entrance to that same parking lot and drove north and was kind of driving head on with the car. And me and Trooper Mater kind of stopped the car at the same time.
Okay. Did you approach the vehicle?
Yes.
And do you recall how many occupants were in the vehicle?
Yes.
How many?
3.
Which side did you approach on, sir?
I was approaching from the front of the vehicle on the, probably call it the passenger side of the vehicle.
And do you recall where the occupants were positioned in the vehicle?
I remember there being a female driver, a female front passenger, and a male rear passenger.
Do you see any of the occupants here in court today?
Yes.
And who do you see?
Mr. Crabtree.
Where, I'm sorry. Where? And where was he positioned in the vehicle?
He was in the rear seat behind the driver.
Your Honor, I would ask that the record reflect that the witness has identified the defendant as being an occupant of that vehicle.
Any objection?
No, Your Honor.
Identification is noted.
Thank you. Could you describe the lighting in the parking lot?
It was during the day, it was lit.
Were you able to see clearly into the vehicle?
Yes.
And what, if anything, did you note about the defendant's movements within the vehicle?
As I was walking up to the car, I saw him in the back seat, and I could see him from what I could see and tell. It was like he was reaching between his legs. His face was looking down towards the floorboard, and like his shoulders like were moved forward like this almost.
And for the record, Your Honor, the witness has just sort of rolled his shoulders forward and hunched over almost in a C shape, Your Honor, bringing his head toward the floor. Thank you. And what did you do next, sir?
I drew just that type of movement, in my experience, is typically indicative of somebody trying to hide or reach for something, whether it be contraband, a gun, whatever. So I drew my department gun, pointed it at the car, gave them commands to get their hands up, and they complied.
Okay. And so just proceeding with the defendant only, the defendant complied with that command?
Yes.
Okay. And did you have any further contact with the defendant?
No.
Okay. Did you have any further contact with searching or taking into custody anything from the vehicle?
No.
Thank you. I have no further questions for this witness at this time.
Cross-examination.
Good morning. Good morning. You stated that to the best of your, was it to the best of your knowledge, was a EIV no?
Yes.
You didn't actually see the EIV no?
No. So Trooper Riley, who was not in my car or Trooper Mater's car, the plate number was relayed to him on the radio. And because Trooper Mater in his patrol car, his lead, which is the system that we use to run plates, was not working. So before the stop was made, Riley ran the plate, confirmed that it was EIV no, and then relayed that to myself and Trooper Mater before the stop was made.
So Riley read the information off of his lean,
Correct.
which is a computer screen,
Correct.
and he radioed to the other officer,
Trooper Mater, yes, sir.
to Mater, who made the stop.
Correct.
And when you say after the car pulled over, you were approaching the car and you saw Mr. Crampty leaning forward in his seat, he could have been tying his shoes.
It's quite possible. I just saw him lean forward, and it looked like he was reaching something, because at the same time that he was reaching forward, the driver and the front seat passenger were just not moving, and he's the only one that I saw moving, so it caught my attention.
But you couldn't really see what he was doing.
No.
What he was doing wasn't actually illegal.
No.
Thank you. Nothing further, Your Honor. And I would object to the entry of the information about the EIV as all hearsay, since it was relayed to two people and that the current witness doesn't really know whether it was registered as EIV no, or whether there was insurance or there was anything regarding the plate.
Did you want to respond to the objection?
Yes, thank you, Your Honor. It is a common practice and regularly accepted legal principle that officers are working as a team. And if one officer observes something or has information, that officer may be that information may be relayed to officers B or C, who may then take that information as if they had learned it themselves. So it's not an objection as to hearsay.
Thank you. The objection is overruled. Did you want to redirect your witness?
No, thank you, Your Honor. I am satisfied this witness is free to leave.
Trooper Delacour.
Thank you.
You can call your next witness.
Thank you, Your Honor. The people would call to the stand Trooper Alan Mater.
All right, let's see it.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat here. Can you please state both your first and last name and spell it?
Alan Mater, AlanMater.
First and last name and spell it.
Alan Mater, AlanMater.
Thank you. You can proceed, counsel.
Thank you. Good morning, sir. Could you please state your occupation for the record?
Trooper with Michigan State Police,
And how long have you been with the Michigan State Police?
approximately 4 years.
Were you on duty on November 9th, 2021?
Yes.
And what did your duties that day include?
Traffic stops, working the secured city partnership with VCI.
And were you in a marked or unmarked patrol car, sir?
A marked.
Witness can remove his mask. It appears to be bothering him.
No, it's all right. I'm good.
I'm sorry, you said marked, sir?
Yes.
Thank you. And at approximately 1500 hours on that date, do you recall where you were?
Yes, Cedar, Pennsylvania area.
And within the city of Lansing, county of Ingham, state of
Yes.
Michigan? What were you doing at that location, sir?
I conducted a traffic stop.
What type of vehicle?
Four-door sedan.
Do you recall anything further of the vehicle?
I do not. There was 3 occupants in there. But as far as make and model, I don't recall.
Would that be noted in your report?
Yes.
Would it help to refresh your recollection?
Yes, ma'am.
Your Honor, may I approach the witness?
Okay.
Thank you.
All right.
Sir, did having a chance to review your report refresh your recollection?
Yes.
And for the record, Your Honor, I handed the trooper the Michigan State Police report, 11-4413-21. Thank you, sir. What type of vehicle?
White Chevy Impala.
Thank you. And why were you making that traffic stop, sir?
The traffic stop was made for no insurance.
And how did you become aware of that?
My lean was not working, so Keegan, or Trooper Riley, ran the license plate in lane and advised that the car was EIV no, which no insurance.
And to be clear, LEAN, L-E-I-N, what does that stand for, sir?
Law Enforcement Information Network.
Thank you. And after receiving that information then from Trooper Riley, you proceeded to effectuate a traffic stop?
Yes.
Okay. And how did you do that?
I initiated my overhead emergency lights and pulled into the listed venue.
Did you approach the vehicle?
I did.
And as you approached, were you able to see into the vehicle?
No, I could not.
Did you indicate, though, how many occupants were in the vehicle?
So, okay. Yes, I could see there was 3 occupants, but as far as I was not, as I approached, I wasn't close enough to see into the vehicle.
Understood. I'm sorry. Thank you for that clarification. So you could see the occupants, but nothing else?
Correct.
Okay. Could you see where the occupants were positioned?
Yes. There was a front passenger, a driver, and a rear driver's side passenger.
Thank you. And which side did you approach, sir?
The driver's side.
And as you approached, what, if anything, did you make note of?
So when I initiated my traffic stop, Trooper Delapel was in his own fully marked patrol car. He was a few car lengths back behind me. I initiated the traffic stop, and to back me, he just pulls into the closest drive and pulls in front of the vehicle. As we approach the vehicle, he draws his firearm and yells to me that he has the back passenger reaching for something towards the floorboard of the vehicle.
And what did that cause you to do?
Make contact with the rear passenger.
Would you normally approach and speak with the driver first?
Yes,
But because of the situation, you elected to make contact with the rear passenger?
correct.
Okay. And do you see that rear passenger here today?
I do.
And could you please indicate for the court what that passenger on the date of 11/9/21 is wearing in court today?
Blue shirt, white mask, tattoos on his face.
Thank you, Your Honor. May the record reflect that the witness has identified the defendant.
Any objection?
No objection.
So noted.
Thank you. What happened next, sir?
So I have prior knowledge of Mr. Crabtree from prior contacts. So I knew that he had a probation violation, pulled him out of the vehicle, and he was detained.
Did you make any notes as you pulled him from the vehicle?
What was that?
Did
Sorry.
you make any notes or observations of anything as you pulled him from the vehicle?
Yeah, as I pulled him from the vehicle, I observed revolver on the floorboard.
And where on the floorboard?
Right between where his legs were.
Who secured that firearm?
Oh, I'm not sure whether I did or Trooper Jupin did.
Okay. What did you do next?
Brought Mr. Crabtree back in front of my vehicle, and then Trooper Jupin searched him, and the rest of the occupants were detained by the other officers on scene.
Did there come a time when the vehicle was searched?
Yes.
And was that done by you?
That was done by myself and Trooper Jupin.
What specifically did you remove, if anything, from the vehicle?
I removed 2 bags of suspected narcotics
And where were those bags located?
in a black shoe bag in the back.
Where in the back? Do you recall,
In
sir?
the back seat, right on the middle seat next to where Mr. Crabtree was sitting.
Did you remove anything else from the vehicle?
There was also ammunition that matched the ammunition in the firearm.
Where was that removed from?
The same bag.
Was anything else removed either from the bag or the vehicle?
Trooper Jupin removed I think it was 1 round from the trunk of the vehicle.
Now, did you do anything with the suspected narcotics that you removed from the vehicle?
Yes,
What did you do?
I put them in a bag, secured them in my car, and then I true narked them at the post.
And what is true narking, sir?
True narc, it's a tool for identifying what a narcotic is. So pretty much you turn it on, you run a test to make sure it's working correctly. It'll say the test is complete. You hold it, so you've got your narcotics in a clear plastic bag. You hold it to the narcotic, push the start button, run it. It'll scan whatever substance it's on, tell you what it is, and then once it tells you what it is, you then run a test again to make sure nothing is messed up. Make sure you get the clear signal on it that says it's working.
Okay, so you're essentially testing this before and after running a sample test. Is that a fair summary?
Correct.
Okay, and are you trained to use a true narc analyzer? Or I'm sorry, a true narc instrument?
I am.
And with regard to, you said there were 2 baggies of suspected narcotics. Did you test both of them?
I did.
And what were the results for each of them individually, if you recall?
If I recall, it is, I know 1 tested positive for meth. 2 did not return. They showed inconclusive.
When you say two, you mean sample one,
Like,
methamphetamine,
Two
sample two?
samples, yes, 2 samples came inconclusive,
But one tested positive for methamphetamine?
correct.
Thank you. Now, did you have the opportunity to have any conversations with Mr. Crabtree?
I did,
And where did those occur?
in my patrol car and then at the jail.
Reference your patrol car. Did you provide him Miranda rights
I
prior
did.
to speaking with him?
I did.
Okay. And did he acknowledge that he understood those rights?
He did.
Did he indicate that he would speak with you?
Yes.
And what did he advise?
I don't remember word for word what he advised, but he advised that he had bought the gun off somebody from the street, not an actual dealer. That the reason he got the gun was because the vice lords were essentially headed out for him. And then that the suspected narcotics belonged to him.
Did he, if you recall, acknowledge what specifically the narcotics were?
Meth,
And he said that to you?
correct.
Okay. And did you have any further conversation about the methamphetamine?
We did.
And what was that?
It was, I'm not sure whether my camera had been shut off or not. We were on our way up in the jail. And he said, I was just trying to make some money. And I said, with the dope? And he said, yes.
Thank you. Do you recall the type of weapon, sir?
I do not. All I know is it was a revolver.
Thank you. Is a revolver a type of pistol?
Yes.
Thank you, Your Honor. I have nothing further for this witness at this time.
Cross-examination.
Good morning.
Morning, how are you?
Fine, thanks. So going back to the initiation of the stop, you testified that you heard over the radio that it came back EIN no. Is that
EIV, no.
EIV no, pardon
Yes.
me. And that's inconsistent with what you wrote in your report. If I show you the report, do you think it might refresh your memory?
Sure.
Mind if I approach, Your Honor?
Are you asking him was it inconsistent with what you were for, or are you telling him? I'm not sure.
I'm asking him if it's
Okay.
inconsistent. Do you remember what you wrote in your report?
Yeah, that I stopped it for no insurance. After Trooper Riley advised me that there was no insurance on the vehicle.
If I show you the report and it's inconsistent with what you're saying, you think it would perhaps change your recollection of what happened that day?
No.
No?
That's what happened.
Okay, so when you wrote in your report that there was no return information in lien or SOS for the vehicle?
Yeah, when we ran it, but it's still showing no insurance.
Okay. And that, but
Like
you
there
didn't
was
write
no-
that in the report, right?
There was no return, there was no vehicle, there was no insurance, nothing like that.
Okay, so you recall that there was no report on the plate? Is that when you
Correct.
sent the information for the plate number into your system, there was nothing there, right?
Right.
Is that the basis for pulling them over?
Yeah, there's no return on the plate. It's no good. The plate's no good. The no insurance, like that's the legal stop.
I understand.
Okay.
So when you got no information about the plate,
Mhm.
what was the law that they had broken that you thought they?
Unregistered vehicle or improper plate.
Wouldn't that, if you ran the plate and it was an improper plate, wouldn't it register some other vehicle?
Right. I guess I'm confused what you're asking. The plate wasn't that good.
I'm just, the way it reads here is there was no information, and I just, from that, I was trying to figure out what law you had broken if there's no information.
I didn't say he did. The
Well-
reason for the traffic stop was to stop the vehicle.
Right,
I ID'd him when I went up to the vehicle.
right? But when you initially pulled him over, did you have any reason to believe he'd broken any laws?
I'm confused.
To be clear, Your Honor, that assumes facts, not evidence. He wasn't the driver. The testimony has been very clear that he was a passenger, and I believe it was Trooper Mader's statement just now. I didn't pull him over. I pulled over the vehicle. So I'd like to just clarify, Mader is speaking as to the traffic stop as it relates to the vehicle, and Mr. Abbott seems to be asking questions about his client specifically.
The objection is sustained. They're asking when he pulled him over, and he's
Okay,
been clear
excuse
that
me.
there was a
Rephrase it.
female that was driving.
All right. Were you driving?
Yeah.
Okay. Awesome. And when you pulled the car over, what was the basis for pulling the car over?
There was no return on the plate. I've told you 3 times now.
All right, I get that, and that's what it says, but I'm trying to figure out what specific law had been violated by the driver of the vehicle when you pulled the vehicle over.
Your Honor, objection asked and answered. He said unregistered vehicle.
The objection sustained.
Okay. Then I'll ask some other questions. Thank you. You tested the stuff you found with TrueNarc?
I did.
And you stated that before you use that device, you run a self-test?
Correct.
So it says that it's working?
Correct.
Does it always say it's working?
No, it doesn't.
And, but it says it was working today? The day you tested it?
Yeah.
Okay. And how does that self-test work? What is that doing when you're self-testing?
Honestly, I couldn't tell you. I'm not a specialist in TrueNarc. I just have been trained on how to use it.
Okay. Have you ever pushed the button and it says it's not working?
Yeah, it shows up as an error on the screen.
I've had this argument with you before, so I'm not going to try it again.
Me?
Yes, Your Honor, about TrueNarc. Your interview in the car regarding the Miranda, was that on video?
Yes, it was.
Okay, and you submitted that video to the
Yes, I have.
prosecutor's office?
Yes, I have.
Nothing further, Your Honor. Thank you.
Thank you. Trooper Mader, I'm just going to clarify, because when you ran the plate and no information comes back, is that the same as the statement that you made? Is it no EID? Is that what it is? Is that the
Right.
same?
So generally so I didn't run the plate.
Oh, when someone runs the plate.
Trooper Riley ran the plate because my lien, we had just got out and I hadn't got my lien up yet and it wasn't out. So Trooper Riley runs the plate, so there's no vehicle information. No vehicle information generally means it's not registered and it's not insured.
Okay, thank you for clarifying that. Any redirect?
No, Your Honor, thank you.
Thank you, Trooper, you may be excused. Call your next witness.
Your Honor, thank you. The people have no further witnesses. We do that. Geez, I know he can go.
Thank you.
But Your Honor, the people would move at this time for admission of People's Proposed Exhibit Number 1. It is a certified copy of the commitment to jail of Mr. Crabtree dated June 16th, 2021, signed by the Honorable James J. Moe, showing the conviction of the charge that is the underlying offense for the count 3 felon in possession charge. The people would move for that admission, Your Honor, pursuant to MCL 766.11B.
Any objection?
No, Your Honor, I've seen the document.
Thank you.
May I approach, Your Honor?
You may.
Thank you.
People exhibit 1 is it admitted?
Thank you, Your Honor.
Any additional proofs for the prosecution?
No, Your Honor, thank you. The people have nothing further.
Thank you. Mr. Abbott, are you calling any witnesses?
No, thank you.
Okay, you can proceed to argument.
Thank you, Your Honor. In this case, the defendant has been charged with 3 separate felonies alleged to have occurred on or about November 9th, 2021 at Cedar Street within the city of Lansing, Ingham County, Michigan. The court had the opportunity to hear from 2 Michigan State troopers today who indicated that they were on patrol, that the plate was run, although not by either of the individuals present today, and it came back with a invalid plate information. Plates in the state of Michigan, Your Honor, or vehicles, pardon me, please, are required to be registered, and to operate a motor vehicle without a proper plate, whether it be improper or just not registered at all, is a violation of the motor vehicle code, for which the police may make a traffic stop. Upon making that stop, Your Honor, the two troopers that testified here today approached the vehicle. They identified Mr. Crabtree, the defendant, as an occupant of that vehicle. Trooper Delapel testified about the movements that Mr. Crabtree was making, which later, as he stated to Trooper Mater, were because he was attempting to hide the gun. He knew that it was there. He acknowledges the gun, Your Honor. He is, Trooper Mater, in addition to his contact with the defendant, seizes materials from the vehicle that are located in a bag in the rear seat, which Mr. Crabtree later acknowledges are his narcotics. Those narcotics are tested on the road using the TrueNarc system, or at the station using the TrueNarc system, Your Honor. They return a test positive for methamphetamine, which is consistent with the defendant's statements that he knew it was meth, it was his, and that he was using it to make some money. Your Honor, the people believe that they have satisfied by a basis of probable cause the elements for each of counts 1 and 2, with the admission of People's Exhibit 1, Your Honor, have satisfied the elements of count 3, and ask that this matter be bound over as alleged on the complaint to the circuit court.
I'll leave it to the court's discretion. Thank you.
Towards preliminary examination. At the time of examination, Mr. Crabtree, the burden is on the prosecution. They have the burden to establish probable cause that a crime was committed and probable cause to charge you with the crime. We heard testimony today from both Trooper Delapel and Trooper Alan Mater from Michigan State Police Department, and they described to the court a traffic offense or a traffic stop that occurred on the date of November 9, 2021 at the area of Cedar Street in Pennsylvania, which is in the city of Lansing, Ingham County, venue in this court appropriate. He stated that the purpose or the reason for the traffic stop was because the plate information came, or there was no plate information that came back when the plate was ran in lane. When they effectuated the traffic stop, the defendant, who was identified by both officers, was the backseat passenger. He was described as making movements, as reaching forward in between his legs. Trooper Delapel demonstrated a hunching forward motion, indicating that he believed, based on his experience, that Mr. Crabtree may have been trying to hide something. Nonetheless, the Trooper Mater testified that he was familiar with Mr. Crabtree from prior experience, and that he knew that Mr. Crabtree had a probation violation. For that reason, Mr. Crabtree was removed from the vehicle. When removed from the vehicle, the officers observed in plain view a pistol or a revolver, as well as two shoe bags of narcotics or suspected narcotics. They were TrueNarc tested. One came back as meth. The others were inconclusive. However, in transporting the defendant to the jail, the trooper testified that the defendant admitted that it was meth and that he was trying to make some money, and that the revolver also belonged to him, that he bought it off the street. The court is satisfied that that content is sufficient to establish probable cause as to count 1, controlled substance delivery, manufacture of methamphetamine. So that will be bound over to the circuit court. Count 2, weapons carrying concealed. Counts 3, weapons, firearm found in possession. The court is also in receipt of People's Exhibit 1, plus the testimony evidence of the officers, makes it sufficient for the court to bind over as to count 2 and 3 to the circuit court. So all counts as indicated in the original complaint will be bound over to the circuit court for further proceeding. The bind over date is going to be December 8th. You do not need to appear in circuit court that date. That's just the date they'll get the file from this court. When they receive the file, they'll set your next court date, which will be a pre-trial. Mr. Apple will be made aware of that date, okay? Mr. Crabtree,
Yes, Your Honor.
do you have any questions today?
No, Your Honor.
Current bond is set at $10,000 cash surety that will continue. Any additional matters for the record?
Nothing for the people, thank you.
Nothing for the defense, Your Honor.
Thank you, you're all set.
Um, I'd like to let Kathy do the report. Yeah, she has to grant.
Mrs. House Bill.
Oh, thank you, Honor. Oh, I see. Your Honor, I'm sorry, hold on.
Your Honor, I'm gonna go downstairs and talk to
We're gonna
Mr.
have-
Martin.
Mr. Martin, okay. Is Jared Austin here? I don't know.
Hey, John.
I don't know what's going on with
Yes.
over
Yeah,
Is-
no, I appreciate it.
Jared still in Judge Alderson's court by chance? Saw him there earlier. Your Honor.
Okay, just want to know what's going on with Holsinger.
Thank you, and may we address Ms. Bernard's case, Your Honor?
I don't have the file in here.
Jared is on the record.
Okay.
Thank you.
Thank you. We need to go grab the file. Is Ms. Bernard here?
She is, Your Honor.
Ms. Bernard, can you come to your attorney?
Are we recording?
We're not recording, we're live.
On the YouTubes?
Yep,
It's terrifying.
probably millions of people watching right now.
I know, I have, I think, at least 3 subscribers, I think, Your Honor. Pretty big deal.
It's a thing now.
It-
People want like to watch more.
It is pretty popular, especially with like Judge Middleton and St. John's, and it's got like 30,000 followers.
I feel like we should do something more exciting and colorful then. Feel like
No, you should probably don't.
Please
You
don't.
should please. I think
For my
you're doing just
cross-examination,
fine.
I'll do an
I
interpretive
think you're doing
dance.
really well. You got a little color in your tie there.
Oh, if you're gonna do that, can you remove the rule that we're not allowed to record these hearings?
That is gonna be okay.
Yeah, recording.
Good, we're live.
We're on the YouTubes.
Okay.
That one officer. The command's been calling him on the radio. Can you come to this post? He's like, I'm in court. No.
Here, explain the call.
Which matter are you on, Ms. Eisenhower?
Dakota Martin, Your Honor.
I'm gonna have to record it. Thank you.
Sat in the office and I went over to criminal and nobody can find it. So I'm not sure what it did. It's entered in though, because it's in my status.
It's not on the workstation at all.
No, it's clean.
on the record in the matter of the people of the state of Michigan versus Alicia Bernard. File number is 20-03448. FY council appearance.
Thank you, Your Honor. Aaron Husfield on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Bernard, who is present and standing to my right at this time, Your Honor.
Thank you. Good morning, Ms. Bernard.
Good morning, Mr. Simmons.
Today's the date, but not the time set for your exam.
I apologize.
You're supposed to be here at 8:30. What happened?
Since we were doing virtual, I was trying to get in contact with Mr. Milks a week ago. He was out of town. Then he contacted me yesterday and I called him back and he said that it was gonna be in person. I was already out of town for the holidays. So, I have a small baby. I got her up, got her here and tried to get here on time, but it didn't work out the way I anticipated. I mean, I'm not driving right now, so the person that gave me a ride, they didn't get off work until 7, so I couldn't leave any earlier. So they were ready.
Okay. Did you appear via Zoom before for the
Yeah.
PCC? I don't recall us ever telling you can appear for Zoom for your exam.
And Your Honor, that is correct. That regarding the exam, there has been several times in this case where it's been set for preliminary exam where we appeared over Zoom asking for an adjournment due to issues regarding an out-of-court identification of a lineup, essentially. And I will report everything my client has said is true. I've been out for the past week or so, and it was, including yesterday, and it was only within that week that I was gone, Your Honor, that we did receive a supplemental report regarding the lineup. There are still identification issues, as the complaining witness could not identify my client, but says that it's due to some anomaly with the photo itself, Your Honor. We are asking the prosecutor to do a correct, or I'm sorry, not the prosecutor, but that we can facilitate a proper identification or out-of-court identification, Your Honor, using a correct photo this time, as that would be fair for my client. In accordance with due process, as my client cannot be independently identified if sitting next to me in court, being the only person next to me. Your Honor, my client does understand that she is obviously late. If I may, Your Honor, if we could reinstate my client's bond, we do recognize that there has been subpoena fees. I believe that they're about $6 still or so.
For a half day rate, it is $6, Your Honor.
And there was $2 in parking costs that the complaining witness incurred, and I believe the prosecutor and I were here when she heard that, as well as gas, which I'm estimating to be $5. My client paid $13 to cover those fees, to put parties at a hold for this one. There were no officers that were called today, nor do I believe there would have been any officers called today, just because the one officer that would be called is out of town. So, Your Honor, I'm asking if the court could reinstate bond as it was. Obviously, if my client needs to pay $13 or something, or whatever it is to cover those costs, Your Honor.
Okay, so that I'm clear, so that there's still an issue with the lineup, is that correct?
That's the defense's position, absolutely, Your Honor.
Okay, did you want to address that?
Thank you, Your Honor. Mr. Milks, just moments before we went on the record, requested that I have a new lineup facilitated. I have not really had an opportunity, Your Honor, to respond to him or to look at the legal aspect of whether that is required or appropriate in the case. Certainly, if the people are going to do that, Your Honor, we would need some time to have this, this putting together a photo lineup, Your Honor, requires an analyst, requires the detective, requires the scheduling. So having this matter reset for a week or two, I don't know that we could properly get that done, have a supplemental report made, and get it to defense counsel. And then we're back before Your Honor with the discovery issue again. So if that is going to be requested of the people, then I understand certainly their position. And if the court orders the people to do that, we will comply with any of the court's orders. I would simply ask that this matter be set out 30 days or so in order to properly facilitate that and have all the information to appear before your honor again.
That is what you're requesting, correct?
That's correct, Your Honor.
I
Thank
would
you.
imagine he's not objecting for it to be set out for the 30 days to allow that to be facilitated. I will quash the bench warrant and reinstate the bond under the circumstances. Ma'am, your preliminary examination will be in person, okay, ma'am?
I would note that and it will not happen again, Your Honor.
Well, we're into January for dates now.
So it's gonna be January 7th at 8:30.
January 7th at 8:30
In person.
in person.
Absolutely.
Okay.
Yeah.
And I don't believe that we need an additional PCC.
I don't think so.
Mr. Mills and I have good communication, Your Honor, and we will handle anything behind the scenes.
Thank you. Any additional matters for the record?
Nothing for the people, thank you.
And nothing for the defense, Your Honor. Thank you.
You're all set. Okay, who's next?
All right.
Mr. Abbott? Are we proceeding exam on Martin?
We're going to waive preliminary exam, Your Honor, on
Okay, this is Mr. Martin here.
yes.
Yes.
On the record of the matter, the people of the state of Michigan versus Dakota Lee Michael Martin, file number 21-03058 FY, council appearance.
Good morning, Your Honor. Theodora Eisenhut on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Martin. He's present and standing to my right.
Thank you. Today's the date that's set for preliminary examination, and parties are indicating they're going to unconditionally waive their exam today. Is that correct?
Yes, Your Honor, that is the people's position.
Yes, Your Honor.
Is there an offer extended?
Not at this time, Your Honor, but negotiations will continue in the circuit court.
Okay, Mr. Martin, you understand that you have a constitutional right to have a preliminary examination here in the district court?
Yes.
You understand that at the time of the preliminary examination, you have the right to have the prosecution establish their burden of probable cause. So they need to bring sufficient evidence to establish probable cause that a crime was committed, and then probable cause to charge you with that crime. Do you understand that?
Yes.
You wish to unconditionally waive your exam today?
Yes.
So unconditionally mean you can't come back later and say you want your exam. Is that
Yes, ma'am.
accurate? Okay. This matter will then be brought over to the circuit court. You'll have no hearing here to establish probable cause, and then negotiations will take place further at the circuit court level. You understand that?
Yes.
Anybody making any threats to you to get you to waive your exam today?
No, ma'am.
Anybody promising you anything for you to waive your exam?
No, ma'am.
I find your waiver to be made freely and voluntarily. I'll bind the matter over as filed in the complaint over to the circuit court. The bind over date's gonna be December 8th, 2021. You do not need to appear in circuit court that date. This is just the date they'll get the file from this court. Your next court date will be set, and Mr. Abbott will be made aware of your next court date, okay? Do you have any questions today? Bond is set at 7,500 cash surety. That will continue. Any additional matters for the record?
That from the people, Your Honor. Thank you.
Your Honor, we request the court reconsider bond at $7,500. It's more than he can afford. He's got a job here in town that he thinks is still waiting for him at Applebee's. He's well established in the community. I think his risk of flight is low. He's got a tether on, which he'd be able to pay for, and he's willing to comply with the court's order. He lives in Holt, and the alleged victim here lives in Lansing, so they're not. There's little chance that they would accidentally run into each other, and it's easy for him to stay away from her home. So I'd ask the court to consider reducing bond and allowing him to get back to work pending trial. Thank you.
Counsel.
Thank you, Your Honor. Your Honor, these are serious charges that have now been over to the circuit, or bound over to the circuit court against a child that was under the age of 13 at the time. She does live in the area, as does the defendant. In addition, Your Honor, now that the case has been bound over to the circuit court, there is significant being in the same community, or, well, no, let me put it this way. I'm not aware of where the defendant is currently living, or whether or not that would be within location close to the victim. I do understand that the defendant does have a tether as a part of his bond conditions. If the court is looking at lowering that bond, I would ask that there be victim notification added to those bond conditions. In addition, Your Honor, it is the people's position that a $7,500 bond as set in this case is not inappropriate given the nature of these charges and the seriousness of this case.
The court understands your position, Mr. Abbott, that your client's not able to afford the bond, but that's not anything that the court is to take into consideration when setting the bond. The bond was set at $7,500 cash surety. I find that bond to be appropriately set, so the court will not be amending the bond. The bond will continue as is. Any additional matters for the record?
That's from the people, Your Honor. Thank you.
No, thank you.
You're all set. Mr. I think Austin was for Judge Alderson. Are we running Lopez?
Your Honor, there is the potential that this will need to be adjourned due to you want to, don't want to miss potential breakdown between attorney-client on the defense side.
Okay, well, we'll wait for him to be brought up then.
Thank you, Your Honor.
Okay, and then we don't, I'm not sure what's going on with Posting still.
Neither am I, Your Honor. The last update we had is that Mr. Austin was on the record. Now that the court has cleared out, I will proceed over and see if that is still a true statement.
Sounds good, thank you.
Thank you.
You say you don't actually cook?
No.
on the record in the matter of the people of the state of Michigan versus Juan Lopez, file number is 21-02696. FY, council appearance, please.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer for the people.
Good morning, Your Honor. Attorney Brett Levine on behalf of Juan Jose Lopez, who's present and seated to my right.
Thank you. Today's the date that was set for preliminary examination. Are we ready to proceed on this?
The people are, Your Honor, though I would leave this to the defense.
Here, thank you, Your Honor. So there's been a little bit of a breakdown in communication relationship between attorney and client. There's certain things that I'll say this as carefully as I can. I think even allegations that are surfacing are inconsistent with some of the advice that's been given. And it's my understanding indirectly through my client's significant other that he wants to get the services of the public better. He has every right to do that. So.
Oh, you've been retained?
I have been retained.
Okay. Mr. Lopez, can you stand up, please? Okay, you hired Mr. Levine to represent you?
Yes.
Okay. And things aren't working out?
Yeah.
Okay, I need, without getting into any protected information, I need some information to establish if in fact there is a breakdown.
Sure. So again, without conceding the object of anything that I'm saying right now, it's still an allegation. There's allegations about going phone calls to the alleged victim, and that trails into other matters. I want to be as careful as I can. Again, it's kind of like walking in a landmine. I don't want to step on the wrong thing. His legal interest is more important than anything that I have, here outside of that. But based on that, I think it soured up communication a little bit. I tend to be direct and not unforgiving, but particularly direct. And I understand that can, it's not something that's well received at times.
Okay, well, I recognize there may have been some sour communication, but that doesn't mean that the relationship has broken down.
Sure.
Why do you want another attorney?
Yeah, I just feel comfortable with an attorney right now.
I'm sorry?
I just feel comfortable right now with another attorney.
You don't feel comfortable? Are you guys arguing?
I just want another attorney right now.
No, I'm asking you a question. You answer it. Are you all arguing?
No, ma'am.
You're not arguing? Okay. You just don't like the positions that he's advising you on?
Yes, disagreements we have on some other things.
About legal things?
Yes.
Okay. And about strategy, is that the disagreement? Okay. And you believe you have a better strategy?
I just want to get another lawyer.
Well, that wasn't my question.
Yes, I understand this.
Okay. I'm not satisfied that there's been a breakdown based on that. I'm sorry that you're no longer satisfied with the lawyer that you hired, but that's the person you hired. Unless you're telling me you're legally trained or you have a Juris Doctorate, I don't see why you think that you have better idea as to legal strategy than the person you hired. Not to say that you're going to disagree or agree on those things, but that's what you counsel about. You hire to counsel for them to tell you what's in your best interest. He has a reputation to protect. Do you think he's trying to concede his reputation?
No.
So I believe he's advocating zealously and has since the beginning and the onset of him appearing on your behalf in this case. And so unless you have something else that you feel to share, I don't believe that there's been a breakdown in communication. I think you can go shop around and find someone to do what you want them to do. And that's not how this works. So the request to withdraw is going to be denied. Are we ready to proceed?
Yes, Your Honor. Though first, I would like to put the offer that is being denied on the record. This offer is expiring at the commencement of the preliminary examination.
Okay, you can.
The defendant is currently facing count 1 of armed robbery, which is a maximum penalty of life. Count 2, home invasion in the first degree, which is a maximum penalty of up to 20 years in prison, and is a discretionary consecutive to every other count. Count 3, unlawful imprisonment, which is a maximum penalty of up to 15 years. Count 4, felonious assault, maximum penalty of only 4 years. Count 5, domestic violence, which is a 93-day misdemeanor. The offer from the people was that the defendant plead to count 4, felonious assault, count 5, domestic violence, and added count 6, which is attempted unlawful imprisonment. The people dismissed the 3 significant charges, most significant, of armed robbery, home evasion in first degree, and unlawful imprisonment. As charged, his minimum guideline range is for the life offense 108 to 180 months, 108 to 180. And for the home invasion, 84 to 140. I say those separately because there is discretionary consecutive, meaning as charged, his minimum guideline, his minimum sentence could be between 192 months and 320 is the minimum. The offer has guidelines of 14 to 29 months. And additionally, because I forgot to state it there, the people are investigating witness interference charges in a criminal case of 10 years or more, which is a 10-year felony, which is consecutive to the charges he's already facing. That carries guidelines between 10 to 23 months. As part of the Kilgore Agreement, the people agree not to pursue witness interference felony charges for contacts that were made to Maria Salas from the jail prior to the plea. If the defendant wanted to waive the examination, we keep that offer open up at the circuit court, but going through with the examination, that offer is going to be terminated and will not be coming back.
Okay. So Mr. Lopez, you heard the offer that's been extended to you. Today is the date set for preliminary examination. The burden here is just that of probable cause. Probable cause that a crime was committed and probable cause to charge you with the crime. This is not a beyond a reasonable doubt burden. That's your right at trial. You've counseled with your attorney. Do you want to accept or decline the offer at this time?
Accept.
You wanna accept-
I want to waive.
the exam.
Yeah,
And
exam.
okay,
and
and
consider-
keep the offer open. Okay. Okay. Okay, and so I just explained again the burden of the prosecution today. It's the low burden, but it's still your constitutional right to have that. Has anybody made any promises, and I'm not talking about the offer, anything else to get you to waive your exam today?
No, ma'am.
Is anybody threatening you to get you to waive your exam?
No, ma'am.
Okay, I find your waiver to be made freely and voluntarily. I'll bind the matter over to the circuit court for further proceedings. The offer will remain open as indicated by the prosecutor, so you can have further negotiations at the circuit court level. Your bind over date's going to be December 8th, 2021, but that's not a date that you're going to be required to appear in circuit court. That's just the date that they're going to get filed from this court. They'll set your next court date, which will be a pre-trial in circuit court. Your attorney will be made aware of that date, okay? Do you have any questions today?
No, ma'am.
That's not, thank you.
I'm sorry?
I was saying, no, thank you, Your Honor.
Okay, any additional matters in the record?
Correct me if I'm wrong, but I didn't hear that the exam was unconditionally waived, and I just want to make sure it's
Oh.
clear that you can't come back to the examination.
Thank you. Did you recognize it's an unconditional waiver, correct, sir? Can you speak up?
Yes.
Okay, you can't come back later and say you want your exam. So again, I find the waiver to be freely and voluntarily made, so it will be unconditionally waived. And did you have any other questions, sir?
No, ma'am.
Any additional matters for the record?
Nothing from the people, Your Honor.
My question from the defense, Your Honor. Thank you.
Thank you.